I want to begin by playing a game. Let's suppose that I've started a company, and I'm in the business of gathering personal information about you. And so what I'd like you to do is write down something about yourself on a piece of paper and place it into this imaginary bin. It doesn't have to be your deepest, darkest secret, but it should be something about yourself that people in the room might not know. And let me just say this at the outset. I'm your friend, and I value your privacy. And I promise that I will not share what you write with anybody. Your secret is safe with me. In fact, let that be a condition to you writing your secret in the first place. The understanding that only I will see it, and nobody else. That doesn't sound too bad, right? So go ahead, write down a secret, and put it in the bin. Now, as it turns out, one of our classmates, Mark, is also in the secret gathering business, just like me. And he's gathered secrets in the same way that I have, with the exact same understanding of confidentiality. So, for the sake of the game, what's happened is, Mark has gathered secrets from one half of you, and I've gathered secrets from the other half. And neither of us can see the other's secrets, so I only know the secrets that I've collected, and Mark only knows what he collected. And this works pretty well for a while. You have the information, and you give it to me. And in fact, I'm so happy with the information that you've given me that I gave you access to a free email account with unlimited storage. But then I become suspicious. One of you in the room, I think, is not who you claim to be. This person, I think, has one goal: to steal all of your secrets and publish them on the wall for everybody to see. And of course, I don't want to let that happen. So here's the thing. I know I promised I wouldn't share your secrets, but I'm going to break that promise. And I'm not going to tell you about it. So I approach Mark and I say, look, I'm pretty sure someone's trying to steal my secrets, and they may be trying to steal your secrets too. And maybe if we work together and share our secrets with each other, we can protect ourselves. And so as a result, Mark, who you had no agreement with, and with whom you certainly didn't grant consent, is looking at your secrets, and vice versa. And what's more, there's a third person, Sabrina, who runs a different business altogether, and who I think may also benefit from seeing your secrets, and so I share them with her too, again without telling you. Now, it turns out the hunch that I had about one of you being malicious was just that, a hunch. In fact, you're all wonderful, honest people. Go figure. And yet, the promise that I made to you, to keep your information confidential, was broken. And you never knew about it. Well, the scenario that we just played out is not a fiction, but rather one of the central changes that's coming into force with the passage of Bill S-4, the Digital Privacy Act. Bill S-4 is a major amendment to Canada's federal private sector privacy law, the Personal Information Protection and Electronic Documents Act, or PIPEDA for short. That change, in Section 7, allows for the disclosure of your personal information to another organization without your consent that is reasonable for the purposes of investigating a breach of an agreement or a contravention of the laws of Canada for detecting, suppressing, or preventing fraud. And so, in today's presentation, I want to take a closer look at the Digital Privacy Act and ask a very fundamental question. Does this law protect your privacy, or does it hinder it? And the answer, I think, is a little bit of both. Okay, so let's take a step back. In the game, I had you write down a secret. But the reality is, we're sharing our secrets, our personal information, with large companies every moment of every day. Our Google search history, things that we purchased or are thinking about purchasing on Amazon, our activity on Facebook, our credit card information, the list goes on. And these companies, like me, are making a sort of promise to you. A promise that they'll keep your data confidential. And what's becoming increasingly clear is that they are unable to keep that promise. Let's look at a few examples. Home Depot was the subject of a hack in 2014, 56 billion payment cards compromised. Anthem, the second largest US health insurer, hacked in 2015, 80 million records compromised. Target was famously hacked in 2013, 110 million payment cards compromised. Sony, hacked in 2014, the company's entire inner workings exposed. Evernote, popular app for iOS, hacked in 2013, 56 million records compromised. And the list goes on. So it's no surprise then that a major amendment to Canada's private sector privacy law, PIPEDA, has been in the making for several years, with precisely the goal of limiting these types of large-scale attacks. And after going through various incarnations, Bill S-4 was introduced in April 2014 and was passed into law in June 2015. Now, before going any further, it's worth walking through some of the amendments to Bill S-4 just to give you a sense of the scope of the changes. In broad terms, I would categorize the amendments into three buckets. We've kind of discussed one of them, the exemptions to consent in Section 7. That's what would allow a company to share your information without asking you. But there's a couple others that I want to touch on. First, the new notification recording requirements in Section 10. And second, the new so-called sliding scale consent in Section 6.1. I'll speak to each in turn. First, notification requirements. These are some of the most important changes in the Act. The trigger language is that when it's reasonable to believe that a breach creates, quote, a real risk of significant harm to an individual, and it creates the following obligations for organizations. First, they must notify the individuals of the breach. Second, they must notify the Privacy Commissioner. And third, they must keep and maintain records of the breach and provide those records to the Commissioner upon request. So connected to this are the new offenses in Sections 24 and 28, which state that organizations that knowingly contravene the notification obligations are subject to fines of up to $10,000 on summary conviction or up to $100,000 on indictable offense per occurrence. Okay, so let's turn to the consent. The old consent provision was found in Clause 4.3 of Schedule 1 of PIPEDA. And it was pretty simple. It said that basically the knowledge and consent of an individual are required, except where inappropriate. Now the new Section 6.1 creates what some have called a sliding scale of consent, whereby the validity of the consent really depends upon who it is who's granting the consent. The language used is that the individual must, quote, understand the nature, purpose, and consequences of the collection, use, or disclosure that they are consenting to. Now, these two areas, the new valid consent and notification requirements, are not without issues. In fact, many commentators have been critical of these changes. One of them is this guy, Barry Sookman, a well-known Toronto lawyer. His concern with the new consent provision is that it will mean that some policies will be viewed as too complicated for certain groups and not comprehensive enough for others. He's also concerned about what he calls a new Canadian standard for consent. So he's worried that what we're doing here in Canada is not in line with international trends. Mr. Sookman has also been critical of the new fines for organizations who don't comply with the breach notification requirements. Remember, those are in Section 10. His worry here is that the potentially enormous fines would lead to over-reporting of any possible breach, no matter how remote the likelihood, meaning consumers may become desensitized to the constant barrage of notices and thereby ignore the ones that are really serious and the ones that they should be responding to. And I think those concerns are totally valid and are worth exploring in their own right. But the real meat of the Digital Privacy Act, and where I want to focus the remainder of our time today, is right back where we started, with the information sharing provisions in Section 7. And I think these provisions are really important because they cut to the heart of what PIPEDA is all about. Remember, the purpose of PIPEDA is really about balance. Balance between the privacy of individuals and the reasonable collection, use, or disclosure of their personal information in limited circumstances. And I think that's reflected in the purpose provision of PIPEDA in Section 3. So the question is, have we struck the right balance with these new provisions that allow organizations to share your information without your consent? Well, let's look at some different perspectives on this. And one of the things that I found was useful was to plot these perspectives along a continuum, with privacy on one side and disclosure on the other. So let's first turn back to our old friend Barry Sookman. What does he say? Well, he's in favor of disclosure without consent in the manner contemplated by Section 7. And in fact, he goes as far as to say, quote, such an amendment is essential to protecting the public and is perhaps even more important than the new data breach notification amendments. Okay, well, down at the other end, in favor of privacy, is Michael Geist. He's a well-known University of Ottawa law professor. Geist has likened the Section 7 amendments to, quote, warrantless disclosure of personal information and suggests that Canadians' right to privacy is being undermined by these new provisions. Also in favor of privacy is another lawyer, David Fraser from McGuinness Cooper in Halifax. He's concerned about the unintended consequences of the new provisions beyond matters pertaining to data breaches. In particular, Fraser has suggested that internet service providers will now be able to ask telecom companies for internet subscribers' contact information without the consent of the subscriber, potentially opening the door for what's known as copyright trolling, whereby ISPs send letters alleging copyright infringement to thousands of users. And finally, somewhere in the middle is Linda Routledge. She's the Director of Consumer Affairs at the Canadian Bankers Association. Ms. Routledge is in favor of disclosure, but she thinks the language of the amendments to Section 7 are too narrowly worded to allow financial institutions to properly investigate and suppress a full range of criminal activities. So she's in favor of disclosure, but she rejects the way the amendment goes about it. So what's the takeaway from all these perspectives? Well, Barry Sookman makes a good point. If the public can be protected through a reduction in the number and or severity of data breaches, the idea that information sharing between companies, even if we don't know about it, seems like a reasonable trade-off, right? But on the other hand, Michael Geist and others have pointed to a valid concern. This law seems to run counter to our jurisprudence, which typically has required a warrant before this type of information can be disclosed. And if the law has bad unintended consequences, such as the copyright trolling concerns expressed by David Fraser, that's not desirable either. Remember, the Section 7 amendment is engaged upon breach of contract. So the potential for information sharing between organizations that has nothing to do with data breach could be huge. And what's more, Linda Routledge, a representative from the banking industry, has suggested that this amendment will not even allow financial institutions to investigate security breaches in an effective way. In other words, she has said this amendment will not do what it's intended to do. And if that wasn't bad enough, we turn to this guy, Martin Libicki. He's a senior management scientist from RAND, and he says that information sharing in itself isn't even the best way to combat cyber attacks. In his view, the presumption that information sharing will work assumes that hackers will show the same patterns of behavior, or what he calls signatures, over long periods of time. In his view, hackers will simply catch on to what companies are doing and modify their signatures, rendering the act of information sharing completely useless. And if information sharing doesn't help prevent cyber attacks, the result will be that all your information is being shared behind the scenes with no corresponding benefit in the form of increased security. So where does this leave us with Bill S-4? Well, one place that I think we can look for guidance is to our neighbors to the south, the United States, where Barack Obama signed an executive order in February 2015 that's designed to promote private sector information sharing. While the executive order is similar to Bill S-4's Section 7 in many ways, there are three important lessons that I think we can learn from it. First, the executive order contemplates specific information sharing and analysis organizations that are designed to gather and synthesize information relating to a specific industry, sub-industry, or region. This would allow information to be shared in a more useful way, and in my view, helps alleviate some of the concerns expressed by Ms. Routledge, who said that the Canadian law will not allow banks to gather the information that they need in order to properly investigate possible threats. Second, the language of the executive order is much more clearly aimed at cybersecurity risk and framing the purpose of the order as relating to information gathering for that purpose and not for other purposes, such as, for instance, exposing the identities of internet subscribers for copyright trolls, as was raised by David Fraser, as a possible consequence of Bill S-4. Third, the need to protect the privacy and civil liberties of individuals is built right into the language of the executive order. For instance, the order is framed around the principle of minimization, whereby the amount of information being shared must be proportionate to the threat of the breach and must be the minimum amount of information necessary to help prevent the breach. In my view, this alleviates some of the concerns espoused by academics like Michael Geist. Ultimately, I really do think that Bill S-4 is a step in the right direction for Canadian privacy law. But it's not without its flaws, many of which I've canvassed here. To fix some of those flaws, I've suggested that we can look to our American neighbors, who've enacted a similar law in the form of an executive order that, in my view, alleviates many of the concerns expressed by detractors of Bill S-4. But what I hope this presentation has shown, most of all, is that the interplay between privacy and security is a delicate balance. And often, the law will miss the mark, even when I do think Bill S-4 gets a lot of it right. And ultimately, I think it's up to us, as citizens, to be cautious with the information that we share with others and with organizations, and to be responsible internet users. Often, a data breach is not the result of a criminal mastermind, but rather the result of the careless or naive act by an innocent victim. If we act with caution, that in itself will be a huge step forward. So, the next time a company asks you to write down your secrets on a piece of paper, maybe you should think twice.